Good evening, this is John Milburn and this is Laws 11062, Contract B. We're into week 11. Tonight we're dealing with week 10 material to start with. We'll probably look into week 11 material, which is non-assessable, leaving us next week to undertake a review exercise. A couple of things. The first is the importance of statutory interpretation. Just before we came on screen, I had a brief discussion about that. And I'd commend to you as an excellent publication delivered to your inbox, Interpretation Now. It's an initiative organised through the ATO, and it provides excellent updates in terms of current case law regarding statutory interpretation. So it's one of those online publications that it arrives infrequently in the inbox, but is well worth looking at, and I've had the pleasure of contributing to that on occasion. Another thing is the Central Queensland Law mooting team is doing fabulously well. Chris isn't joining us, I think, tonight because he's involved in the semi-final. So I received information that CQU is now into the semi-final, the top 4 out of 9 universities, and is really doing well. So good luck to them. And if they succeed tonight, they go to the grand final in the Supreme Court on Friday evening. So fingers crossed. And if you haven't involved yourself in university life, please consider doing that in a more broad sense by looking at the Law Society for the QLS and for Central Queensland University. So one of your colleagues, Chris, is heavily involved in that as the president. In terms of the second assessment, by now you should have received your feedback and your mark. And overall, I thought the quality of the work was excellent. One of the things that I liked about the presentations collectively was that people genuinely seemed to enjoy it and be comfortable in providing the presentation. One thing I'd like you to think about as you're addressing a court or even a client or whatever it might be is that people do want you to perform well. So rather than go into, for example, a court appearance, dreading it and being fearful, do try to embrace it. So you're there to contribute, to assist. Remember, one of the paramount duties is in the administration of justice, and that prevails against any other duty to which it is inconsistent. So what's one of the best ways of to the duty to the court in the administration of justice is to do a good job. So if you appear before a court, remember the court wants you to do well because it's in their interests. So keep that in mind. And of course, when you're presenting your material, always think about the ethical duties. And many of you, I'm sure, were conscious of that. And one of the threshold outcome skills for the university, turning threshold learning outcome 2, dealing with ethics and professional responsibilities, requires graduates of the university to demonstrate an understanding of ethical decision making and supplement that with an ability to respond to ethical problems as they arise. So it's important that you continue to reflect on your professional responsibilities. We've talked about that a number of times during the unit, and you can have a look at the Queensland Law Society Ethics Centre, as I mentioned earlier. Another thing that is very common that you need to be considering when you're taking instructions or involved in any matter is the question of capacity. And increasingly with an aging population, with increasing number of people with, for example, conditions like dementia, issues around capacity are becoming more prevalent. So a good starting point to consider issues around capacity is the Guardianship and Administration Act. Have a look in Schedule 4 of that legislation and you'll see the appropriate definition, which for a person, for a matter, means that the person is capable of understanding the nature and effect of decisions about the matter, freely and voluntarily making decisions about those matters, and communicating the decisions in some meaningful way. Issues about whether a person has capacity or not are typically litigated in Queensland, in the Queensland Civil and Administrative Tribunal. So in its guardianship jurisdiction, which is very broad, there's a lot of those cases that deal with guardianship, administration, capacity, powers of attorney. But I digress. So this week, we're continuing our discussion around remedies And we're dealing with the intertwining of both common law and equitable remedies. We're dealing with issues around damages, restitution, and introducing the ACL. Now, it's a little funny to say introducing the ACL because we've talked about that a number of times through the unit. And as I've mentioned in the past, even though much of contract law is based on the common law and so many older cases, as you would have seen, in practice, when it comes to litigation, the first thing that we do is consider the Australian consumer law. And therefore, it should not be treated as something which is an afterthought, even though we're presenting it quite late in the piece formally in this unit. But let's first talk about equitable remedies. Now, you may recall from Introduction to Law that there are some basic tenets, the basic principles that apply in relation to equity. And there's a few catchphrases in that regard. One is that equity follows the law. So equitable remedies are available if the court is satisfied that the common law remedy of damages is inadequate and there's no satisfactory remedy in statute law, such as the ACL. So it's an odd maxim in a way because it gives the impression you need to exhaust common law options before you try equitable. In practice, that's not really the case, but it's still part of our general principles of law when you're considering the interplay of equity and common law. But one thing which is very much exercised in the courts when it's dealing with equitable matters is that equitable remedies, whatever they might be, are always discretionary. So damages are available as of right, but so plaintiffs who demonstrate a cause of action to have damages will succeed, but equitable remedies are discretionary. They're available when the court ultimately decides they're available to a party. So judges have discretion as to whether to grant equitable remedies such as specific performance and injunctions. So whenever you're referring to these types of remedies, always remember, of course, that you can ask for but may not necessarily receive the remedy that you seek in that regard. Another principle is one who comes into equity must come with clean hands. Now, what this means is that if you're asking for an equitable remedy, you've got to be prepared to show the court that you are yourself doing everything appropriately and doing it well. In other words, the court will deny equitable remedies that might otherwise be available to litigants that are deserving in circumstances where it can be shown that you as the applicant have done something which, for want of a better term, is bad conduct, or it's a matter of public policy that has been breached. So courts discourage people from acting in a way that is inappropriate, if I can use that very broad term, and that may be one of the reasons why a court would deny you an equitable remedy. So it's appropriate to always consider the actions of your own client, your own position, when you're arguing for an equitable remedy in a court. I've mentioned previously that you should have a look at Section 8 of the Civil Proceedings Act 2011, partly because it's an important provision, but partly to ensure that if you don't understand that section and have a feel for how it works in practice, then you probably need to do some more research and improve your flowchart and your dot points so you can work to that level of saying, I now understand what Section 8 means and how it might apply in practice. Now, before I go on, are there any questions, comments? All good? All right, I'll move on. If you do have any, please interrupt me, unmute the microphone, or just ask through the chat facility. So over the last few weeks, we've talked about these different words and concepts like termination, rescission, repudiation. So just a quick recap, rescission, frequently confused with termination, but it's not termination. Rescission is where a contract or contractual obligations are treated as void ab initio. The contract essentially treated as if it was never formed, the idea is to return the parties to their original position. And it applies for issues around vitiating factors like misrepresentation or mistake. So where a contract is rescinded as a result of rescission, the contract is dissolved, the parties return to their original position. Now, termination, which is in practice far more common, occurs where a contract, that is the contractual obligations, come to an end from the point of the termination onwards. So the contract and the obligations up to the date of termination remain on foot. So there's a conceptual temporal difference there, which may be very important. And termination arises in different sorts of circumstances. And the most obvious is where there's a breach of an essential term. Another is where there's a serious breach of an intermediate term, or there's repudiation of a party of their obligations under an agreement. That's where typically we see parties arguing that they have the right to terminate and actually do effect a termination. So if termination occurs legally, it means that both parties are discharged, but the obligations and rights unconditionally vested before that time don't disappear. A case to support that proposition is a very important case of McDonald against Denny's Lascelles. It's 1933, 48 CLR 457. Let's make this a little more practical. Tonight I'll talk about real estate transactions just a little. And in real estate transactions, we typically have a contract, and usually it refers to an ability of one party to terminate the contract. For example, a contract might provide that termination is available to a buyer where there's a substantial defect in the seller's title to the land, or there's a material misrepresentation of the land in the contract of sale. That's not to say that rescission wouldn't also necessarily be available. It may be that a party can go either way, but they're really quite separate. So understand clearly that distinction between termination and rescission. I mentioned that one of the key ways in which a party might terminate the contract is to make an allegation that the other party has repudiated the terms of the contract. We should know what repudiation means. It's basically where the party exhibits an unwillingness or inability to render substantial performance of the contract, or provide an indication, intention no longer to be bound by the terms of the contract, which is anticipatory breach, or to fulfill only in a manner that is substantially inconsistent with their obligations. Can anyone give me the name of a case that would support that type of proposition as to when a party is entitled to repudiate? Any thoughts? There's actually a few. One that I go to as a go-to case is Kumpatu Local Aboriginal Land Council and Sandpine. Mentioned it a few times, so it's an important case. 2007-233 CLR 115. Look, another way that a party might demonstrate repudiation is to show an intention to fulfill the contract only in a manner which is substantially inconsistent with their obligations and not in any other way. An example of that is Shevill, SHEVILL, against Builders Licensing Board, again, High Court case, 1982, 149 CLR 620. So we know that repudiation goes beyond breaches of essential terms and serious breaches of non-essential terms. It also deals with anticipatory breaches, as we referred to. And you need to remember the differentiation between essential terms and warranties, which means undertaking a task of interpreting the contract. But a non-essential term can still be important. That is, if a party breaches a non-essential term, it may give rise to a right to the other party to terminate at common law. So it's that grey area, and again, Kumpatu is a good case to reflect that. But to allow termination on that basis, the court must be satisfied that there was an obligation of basic importance to constitute an essential obligation justifying the breach. Now, I mentioned Cheverland Building Licensing Board. Again, it's an important case, and it shows that a party may elect to treat the contract as no longer binding on them, and that will be in response to the other party's repudiation. And if a party renounces their liabilities under the contract, if they evince an intention not to be bound by the contract, then they're said to have repudiated that contract. But here's the difficulty, I've mentioned it earlier. A party can fall into the trap of alleging wrongful repudiation, and that is where they may themselves, as a result of that, be held to have repudiated the contract. So another distinction is between affirmation and termination. So we've distinguished termination versus rescission. So another contrast, and I've mentioned it earlier, termination or affirmation. We see this in the REIQ contract for house and land. So it provides that a seller or buyer may affirm or terminate the contract in certain circumstances. For example, if the deposit isn't paid or some condition which is critical hasn't been fulfilled. And always remember that the ACL will typically sit over the top of these things and provide another avenue for relief or attack through the court system. Now we know that termination or affirmation cannot sit comfortably together. If a party breaches a condition, then the aggrieved party must elect to either terminate or to affirm. They can't do both, and they have to be fairly quick about it. So if a solicitor affirms or terminates the contract for a client, then that election is binding on the client, even if the client had no knowledge of what the solicitor had done. And failing to elect to terminate when entitled to do so will not necessarily be treated as an election to affirm, but conduct can be important and words used can also be very important. Now, Natalie, you've referred to a case. Would you like to mention that? The case of Bowes and Chalier, the court found the buyer repudiated by accepting the goods, and the plaintiff then had to fight for the election. So thank you for that contribution. In terms of other examples of what clients can do, it may be that specific performance will be appropriate, or damages, or maybe even both. Go back to Section 8 of the Civil Proceedings Act, or Civil Liability Act in that regard. Sorry, the Civil Proceedings Act, of course. So it is possible to ask for both specific performance, for example, and damages at the same time. So if a party breaches a contract, breaches a condition of that contract, let's say, then the aggrieved parties may elect to either terminate or affirm. They can't do both, but they may ask for specific performance if they choose to affirm the contract. So they may sue for damages, specific performance, or both. And remember, specific performance is an equitable remedy where the relief that's sought of the court is an order compelling the completion of the contract. That's basically what it comes down to. In conveyancing contracts, time is of the essence. So a good example of how this can work in practice is Legione and Hartley, Legione and Hartley, 1983, 152 CLR 406. And the argument in that case was whether the sellers had lulled the buyers into thinking that the essentiality of time would not be insisted upon. And it's a very interesting case in that it was a very brief exchange that was the heart of this case that ultimately went to the High Court. The court considered the off-the-cuff statement made by a conveyancing clerk who, in response to a request for an extension of time, said, "I think it'll be all right, but I have to get further instructions." That is from the seller. That's what the case was all about. had, as a result of that, the conveyancing clerk bound their client, and were they regarded as having lulled the buyer into thinking that there'd be more time. It was close. It went to a 3-2 majority, and the High Court said that the words of the Secretary did not create anything that was binding on their client. The words of the Secretary did not create an estoppel against the seller. Now, I've just emphasised that word because what I'm showing there is that arguments around estoppel will often feature in these types of arguments around affirmation, termination, repudiation, etc. So in that case of Legione and Hartley, the seller remained entitled to terminate the contract when the buyer was unable to complete on the nominated settlement date, but it was only 3-2 decision. I'll give you a more concrete example. It's Tanwar Enterprises and Cauchy. This is TANWAR Enterprises, and Cauchy's is CAUCHI. It's 2003 217 CLR 315. So what happened in Tanwar? Again, it's a real estate contract. The buyer was Tanwar, entered into a contract to buy 3 properties from the seller, which was Cauchy. Now, there was a problem on the settlement day. The buyer was getting funds from Singapore. Singapore authorities held up the funds that were in transit. So in a way, you could argue the buyer didn't do anything wrong, but time was of the essence of the contract. The buyer could not attend settlement and didn't attend settlement, and the seller terminated the contract. Now, the funds were released through the Singapore authorities the next day. The buyer then said, I'm now ready, willing and able to settle immediately. And again, the matter went to the High Court, all because the buyer was 1 day late in having the funds available. And the High Court held that it was not unconscionable of the sellers to terminate the contract when they did. Again, I've emphasised another word there because we've dealt with issues around unconscionability previously in the unit. So can you see that these sorts of concepts can be introduced as arguments to support a position in relation to certain matters? The case was helpful in that the court did acknowledge that equitable relief may be available if there's a fraud or there's a mistake or there's an accident or a surprise. But the High Court determined that the questions a court should consider are these. Did the seller contribute to the delay? Well, clearly not in that case. Was the breach trivial? No, it wasn't trivial. What damage did the seller suffer? What was the magnitude of the buyer's loss and the seller's gain? And is specific performance adequate? Now, the court said, referring to Legione and Hartley, that the case made it plain that the principles identified as promissory or equitable estoppel may operate to preclude enforcement of a contract so as to stop a party from treating the contract as terminated for failure to meet an essential time stipulation. I know that's a lot of words, but I'd urge you to have a look at those cases and get a feel for a couple of things. The first is, what is the distinction between essential and non-essential terms? How does the involvement of time of the essence change things that might otherwise be the case? What are the ways in which a contract may change, or the rights or remedies of a party change as a result of some statements that might be said or the actions of a party? And how does estoppel and issues around unconscionability come into play with these sorts of arguments? So have something to introduce them in appropriate circumstances if you're answering a legal problem. Now, as a question from Natalie, common law equals time of the essence? Yes, generally. In this case, it wasn't that the common law was strictly relied upon in relation to the arguments around time of the essence. It was because it was specifically in the contract. And in equity, we find that courts are, when exercising equitable jurisdiction, are far less likely to be amenable to an argument that because someone was late by a day, that they should be denied their entitlements under the contract. All right. Yep. So Natalie said if changes the contract, that term is there. All right. Thank you for that. Now, another equitable remedy that's very commonly used in courts is the injunction. And there's a couple of different ways of looking at injunctions. So basically an injunction is an order to undertake or refrain from some specific act. So it can be positive, it can be negative. It can be mandatory or prohibitory, as we say. It can also be interim or it can be final. So if it's interim, if you like, it's interlocutory, which is in most emergency measures, an injunction is used to allow the circumstances of a situation to remain as they were until matters are resolved. So interlocutory injunctions are, for example, emergency measures where you want to ask the court to freeze the position of the opponent party in their current position, maybe to prevent any further harm or to prevent the loss of evidence or the loss of funds that might be used to pay for an appropriate judgment against that party. Injunctions could be mandatory or prohibitive, meaning to stop or to force someone to do something. So usually when we're talking about an injunction, we're talking about something which is prohibitory in nature. That's usually what it is. In other words, an order requiring the respondent to refrain from an action. But it may also be mandatory in the sense that it requires the respondent to actually take positive action. So an injunction can be used either way. And as I mentioned, it's very common to have a request for an interim or temporary, if you like, interlocutory injunction. So, for example, in environmental law, in that context, the purpose of an injunction is to maintain the status quo, the environmental situation, and the application for the interlocutory injunction must show that there is an arguable or prima facie case, and there's a serious question to try, and that the balance of convenience is a paramount consideration in assessing the relative interests and impacts on the parties. Now that general principle applies well beyond environmental law. That's a really common situation. So whenever you're asking for an injunction, generally you need to think about those issues. Do you have an arguable case or a prima facie case? Is there a serious question that needs to be tried? And is the balance of convenience in your client's favour when it comes to the granting or otherwise of an injunction? If you want to go a little further in this area, do have a look at the practice directions of, for example, the Supreme Court that provide the specific rules around the granting of prohibitory injunctions in, for example, issues around Anton Pillar orders or Morava injunctions. That's getting into civil procedure territory, but if you want to get an idea of how injunctions work in practice, have a look at those practice directions and it'll show you very clearly what the court needs to consider and what the parties need to present to the court in order to justify the order that they seek around an injunction. All right, any questions, comments? I know I'm doing a lot of talking. If anyone has anything they wish to say, this would be a great time. Okay, Stephen says, common in building contracts, half the job conducted, finding another contractor is difficult. Yep. Right, so thank you for those contributions. Now, another term that we see in contract law, particularly around the issue of remedies, is restitution. It can be a legal remedy, it can be an equitable remedy, and it arises around a concept of unjust enrichment. So the basic idea of this is that if a party is unjustly enriched at the expense of the other party, then the court may make an order in restitution to correct that injustice. So restitution works closely with issues around unjust enrichment. And an example of that is very commonly seen is an application or an action for a thing called quantum meruit. Has anyone come across that term, quantum meruit? We see it a lot in building and construction cases. Stephen, I gather you might know something about this. A little? Okay. So quantum meruit deals with issues around restitution. Now that's all that I intend to speak to you about tonight in relation to the common law and equitable remedies. Before I move on to the ACL, any questions? All good? All right. So the ACL provides for a very wide range of remedies. These can be monetary penalties, they can be injunctions, they can be damages, they can be compensation orders. There's a very wide range of remedies. Now, pecuniary penalties are available under the ACL where a court does have power to make the orders requiring payment of money as a penalty. And it will do so in circumstances where it's satisfied that a person has contravened or attempted to contravene a prescribed provision of the ACL or has been a party to such a contravention. Now, a word of warning here is that in practice, this usually applies where we have an application, by, for example, by the ACCC against a large corporate entity, and the penalty provisions relate to widespread issues of breaching the ACL. So it's not common that a court will be asked by an individual in a particular matter to make an award of a pecuniary penalty. So what I'm doing is distinguishing pecuniary penalties from other awards that are far more common in a day-to-day situation, like damages, injunctions, compensation orders. So penalties are very uncommon, if you like, at the lower level. Now, but in determining a pecuniary penalty, the court will consider the nature and extent of the act or the omission, any loss or damage suffered, the surrounding circumstances, and importantly, if the party is engaged in similar conduct. So having mentioned pecuniary penalties, by and large, you can put that one to one side. So the other remedies that are available, the first one to come to mind is injunction. The same rules apply for an injunction under the ACL as they do under the common law. Issues around arguable case, whether there's a serious matter to be tried, and the balance of convenience still applies in that regard. So the court needs to be satisfied before giving an injunction under the ACL that a person or party has engaged in or is about to engage in conduct that contravenes the ACL. But again, the principle that the granting of the equitable remedy through an injunction is discretionary applies equally under the ACL as it does when you're applying pure equitable principles. Now, the next one is damages, and damages is available under the ACL where a person suffers loss or damage as a result of contravention of chapters 2 or 3 of the ACL. Then the aggrieved party can recover damages and have a look at the ACL section 236 in that regard. But as always with law, remember issues around time limits. Make sure that's clearly built into your flowchart so you don't miss an obvious mistake. You've got to commence an action for damages within 6 years after the date upon which the cause of action accrued. So they're injunctions. Now, beyond that, the court has a wide discretionary range of orders that might be available to force issues around the ACL, all to do with someone suffering or likely to suffer loss or damage as a result of contravention. And have a look at the chapters 2, 3, and 4 in that regard, which provide for the potential remedies. Now, some of the discretionary orders might be a declaration. So a declaration is a statement by a court of the legal effect of a particular matter presented to it. So it's not ordering an injunction, it's not ordering specific performance, it's not ordering damages. It's basically a declaration is where the court is invited to answer a legal problem and give a legal answer. And in this context, the most common declaration you'd seek is a declaration that a contract is wholly or partly void, for example. Now, other discretionary orders that can be made by a court are an order varying a contract. So remember that the contract can be varied by the court. It might be an order for the refund of money or return of property, which is perhaps in some ways specific performance potentially. It might be an order for compensation, or it might be for some work to be undertaken by way of repair or provision of services or parts, which is really specific performance of the obligation or a mandatory injunction, depending on how you look at it. So I hope that makes sense. Now, we've mentioned earlier in the unit that if you're asking for damages, which is really essentially a common law remedy, but available in equity and certainly available under the ACL, you've still got the basic question that you need to ask yourself. Can anyone give me an idea of the basic question you need to ask yourself before you ask the court for an award of damages? Let's assume that there's a contract that's accepted between the parties. Let's assume that there's been some sort of loss suffered by one of the parties and they asked for damages against the other party. The key question is, well, can you establish that that loss or the damage was because of the respondent's conduct? So again, it comes back to causation. We talked about that earlier in the unit. So you can see that these common law and equitable principles flow into the ACL. Can you remember the name of the case that deals with issues around causation? Any thoughts?
Is it Hadley and Blacksendale?
Hadley and Baxendale? Yes. Yep. Hedley, Byrne and Hiller is also the one that you might want to look at. Okay, so these are some of the cases that will flow into arguments that even though they relate to the ACL. Now, the ACL is so broad that there are other things that can be done. The issues around operation and severance. So one thing that might be done is to consider whether the contract is entirely void as a result of it being completely unfair, or maybe part of it is void and part of it continues to bind the parties without the unfair term. Have a look at the ACL section 23, subsection 2 in that regard. The court will have to consider the argument as to whether it's appropriate for the unfair term to be regarded as severable from the rest of the contract. Now, do you remember we did an exercise on blue line drafting early in the unit? So it's a bit like this, where the court can look at a particular term within a contract and instead of saying the whole contract is out the window, essentially say the contract remains, but for this clause, which is unfair, that's now severed from the agreement. It no longer has binding effect on the parties, but the rest of the contract does. By way of example, and I think this is in your notes, look at the Director of Consumer Affairs against AAPT, which is 2006 VCAT, which is obviously the Victorian counterpart of QCAT 1493. In that case, AAPT included in its standard consumer clause a range of clauses that were found by the tribunal to be completely unfair. I mean, for example, clauses that allowed the telecommunication provider to change the contract unilaterally. That was severed, that's unfair. To charge reconnection fees, even if it wasn't the consumer's fault, severed, it's out the door. Immediately terminate the agreement under a range of circumstances, for example, failing to notify AAPT of a change of address. Unfair, it's severed, it's out the door. Change the terms of service of a prepaid mobile customer in certain circumstances. So rather than declare the whole contract void, those unfair parts of the contract were severed, removed from it. And the question is, could the contract continue to operate if those clauses were removed? And the answer was yes, it can. So the provisions were deemed to be severable in that case. Now, an unfair term is by its nature void, can't be enforced by either party, but we need someone to declare that's the case. Have a look at ACL section 250, which provides that the court does have power to declare certain parts of a contract or a contract to be unfair. And if a party seeks to apply or rely upon terms of an unfair contract, then they may seek orders under the court, from the court rather, under section 237 of the ACL. It's important to understand how these sections work in with each other and link to each other. Now, if the contract can continue to operate with the void term severed, then the contract can do so. But if the contract can't continue once you sever that term, then the entire contract will be terminated by the court order. Now, I mentioned that there are two basic types of pieces of litigation in the ACL. One of these sort of bigger issue matters, and they can be representative actions where an entire class of customer is likely to be affected by the breach of the ACL. AAPT was an example of that. Or it can be individual cases affecting only those two parties. But the same principles apply irrespective of that. Now, because the ACL provides for such a wide range of remedies, another remedy that's very often used and available is the ability of regulators to work with rather than against suppliers or manufacturers who breach the ACL. And one way they might do that is through education, training, communication, encouragement that the company does the right thing. And to support that, to give it some teeth, the ACL provides that regulators can ask for and receive written undertakings from the person or the corporation to support any promises that are made. Have a look at section 218. And if you want to know the significance of undertakings, particularly for lawyers, have a look at the Queensland Law Society Ethics Centre. You'll get a feel for what's involved. Undertakings, when we're talking about legal matters, are actually very powerful things and should not be underestimated in terms of their significance. They're not a soft option. Because, for example, if a court finds that a company has breached its undertaking, the court has a range of options in relation to it. So a court can order the person or company comply with the undertaking, order the person or company pay the government any profit they may have received as a result of a breach of that undertaking, order compensation, or make any other order it considers appropriate. So it's really broad in that regard. Now, finally, for the ACL, there is the remedy of injunctions. We've talked about that in a broader sense, but specifically for the ACL, have a look at section 232, which provides extraordinarily broad injunctive powers for a court to consider. But again, there are some issues that need to be considered. So, number one, the injunction can be applied for by a regulator or any other person. It's very broad, section 232. A person doesn't have to be directly affected by the behaviour complained of. They don't necessarily have to suffer loss or damage. They don't even have to be a party to a contract affected by the ACL. So theoretically, the range of applicants for a court action seeking injunction is extraordinarily broad. Now, the second is the injunction can be not only taken out against the company or the person who's engaged in the direct actions, but it can be anyone who is engaged in or is proposing to engage in a contravention of the ACL, and any person in any way, directly or indirectly, knowingly concerned in or party to such a contravention. That includes accountants, it includes lawyers, it includes directors of the company. So it's very broad injunctive power in that sense. And thirdly, the injunction can be in such term as the court considers appropriate, which means that there's a whole range of things that the ACL will enable a court to do. Remember, an injunction can be prohibitive or it can be mandatory. And if we're looking at something which requires mandatory obligations, the injunction can be used to order the refund of money, transfer of property, ordering a party honour a promise, which is specific performance, or make an order asking a party to destroy or dispose of goods if there's a breach of some fundamental issue around trade practice, for example. So that's all I propose to talk to you about in terms of week 10 content, which here relates to remedies. Any questions or comments? All good? And you've been very patient. I see your comment, Natalie. I won't go there. Thank you. Now, week 11 material, it's non-examinable. We'll have some exam hints next week. International aspects of contract law. When you first look at this topic, you might think, well, that doesn't mean anything to me. But in reality, we're all affected by international contracts practically on a daily basis, aren't we? Because we all use the internet, we're dealing with companies that are based overseas. So these are all international contracts. Now, remember that international law comes from basically 4 sources: treaties, international custom, general principles of law, or subsidiary or secondary sources such as decisions of courts or tribunals, or even writing of jurists. So treaties are probably the first point that you look at when you come to issues around international law. Treaties are also referred to as conventions or records, agreements or protocols. And signature represents an intention to be bound. But in Australia, if it becomes a signatory to a treaty, that doesn't mean it's bound. Internally, at least, the government, the parliament has to make a decision to ratify the treaty, and it does so after consultation with the states. And treaties can be used as the framework for future legislation internally, but it's only when the legislation is introduced that it becomes binding. Now, you can refer to treaties that are signed by, for example, Australia, if you wish to support an argument, but you can't directly argue that because we're a signatory to a treaty, therefore you have these rights that must be enforced. Do have a look at the Rome Convention, Articles 3 and 4, and also the UNIDROIT is it was formerly the International Institution for the Unification of Private Law. There's a good website that provides some good information around these issues to do with international law and international contracts. The other thing that you might want to do is have a look at the, it's another High Court decision. It's Bonython and the Commonwealth. It's Bonython against the Commonwealth. It's 1950, 81 CLR 486. And if the parties decide to make their contract with reference to system of law in a specific jurisdiction, then they're generally able to do that unless there's bad faith can be established. So if the parties have not exercised a right as to the choice of law in the contract, then the courts will then turn to the second Bonython test, which asks with which the transaction has its closest and most real connection, which is a question of fact, and that's where the law will apply to that international contract. And of course, it makes sense that there'll be jurisdictional questions because if you have a contract that says it's governed by the laws of, I don't know, New Zealand, then that's generally where we go. But otherwise, you've got to look at the second limb of Bonython to determine where is the appropriate jurisdiction. Now, that's a flying overview of the content of week 11, which means that for the first time in this unit, we complete week 11, having completed week 11 material. And next week is review and take-home paper preparation. If you haven't looked at my level 3 preparation for take-home papers and examinations, please do so. because that's fundamentally important to get an idea of how you should best prepare for the exam. Now, can I ask, has everyone had a look at the take-home paper information guide that I released in week 10? If you haven't looked at that, please do so, because that together with the level 3 examination material will be critically important for the preparation of work for the final exam. Okay, any questions, comments? All good? All right, and past exams are a good point, starting point as well. I agree with you there, Stephen. Thank you. Okay, well, thank you for your attendance tonight, and we'll see you next week for the final session. If you haven't yet had your say, please consider hitting the big red button, top right-hand corner of Moodle. Have your say, only takes a few minutes. It's very important for me, it's very important for the university generally, and we'd really appreciate it. All the best. We'll see you next week. Bye then.